Do you think this is funny?
I'm allowed to laugh.
The arrested for laughing case. I'm the lawyer on that civil rights lawsuit, and just last night we got a ruling finally on whether or not that police officer gets qualified immunity. He got pulled over here in West Virginia for flashing his headlights at oncoming motorists in order to warn them of a notorious speed trap.
That guy flashing these lights, warning everybody you're sitting there. I'm going after him.
That wasn't a crime, so the officer basically made up a citation, and when he went to give it to my client, he laughed.
And I could take you to jail today for your unsigned registration card, but I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir?
The officer didn't like that. He pulls him out of the car. He ends up putting him in handcuffs.
Step out of the vehicle.
Are you serious?
Place your hands behind your back for me.
Are you serious?
Yes, sir. Place your hands behind your back for me.
Oh, man, you're serious, brother.
I'm not your brother.
I've seen on some of the viral videos floating around the internet all sorts of claims about what actually happened in that case. But they're all wrong. I'm litigating the lawsuit, and it's actually still pending. But there's a huge update. After we filed the lawsuit, that officer and the sheriff of that county asked the federal court to dismiss it and to give the officer qualified immunity, claiming that the driver had no right to warn others about a speed trap and also had no right to laugh at the police. And the court answered those questions. Regarding qualified immunity, the court said this: defendants assert that Deputy Ellison is entitled to qualified immunity because it is debatable and thus not clearly established that flashing one's headlights to warn other motorists is protected speech. That assertion, however, misses the point. Every reasonable officer in the United States is aware that retaliation for First Amendment speech is a violation of a person's constitutional rights. Whereas here, the allegation is that a defendant knew of the speech and reacted to it accordingly, qualified immunity cannot serve as a proper shield. If, just as plaintiff alleges, Deputy Ellison knew of plaintiff's speech, had no probable cause to initiate the stop, and stopped plaintiff anyway because of that speech, then the actions make out a classic First Amendment retaliation claim. In other words, police officers are supposed to know they can't arrest people just for their engaging in protected speech like flashing headlights. Thus, the court denied qualified immunity. The court will address all of these issues again at the summary judgment stage, which will include the testimony of the individuals and all other evidence, including the video footage. We're still in the discovery process. That's still happening. So if you want to follow along, please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on X at John Bryant ESQ. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.